I don't, court prefers, I may be overthinking it, but information regarding between
You're
Mr.
gonna need to speak into the mic.
This court wish that I sent all communication, including that includes getting his client here. Everything, or just the stuff that relates to this?
Why don't you just send everything?
Yes.
I mean, it looks like y'all already had all of that in this the first set of attachments. All right, does that email that you just sent, that's now everything? And those are basically just two conflict letters that Mr. Wright had forwarded. Will that be everything?
I think so. I'm checking.
Okay.
I'm just checking. That was 27/2022 at 8:43 p.m. Right. I'm just looking at all of them. December 22. 22nd. That's 12/27/22 8:43 p.m. So I'm gonna need you to help me out. Okay, I just need you to confirm.
We did yesterday. I think we only had two from 12/27, 4:57 p.m. and 5:06 p.m. Eight. Okay. Oh, okay. The ones that are the paper copy. Okay. Sorry. All right, then that ought to be everything. Can y'all approach for a moment?
I chose Wix for my business because of its massive scope.
I think they doing some deliberations. I'm here.
I'd made an objection on yesterday and asked that be kept out. And I don't recall what the court's ruling was. Can I have some clarity on that, please?
Sure. The court's ruling was that if Miss Love ends up tendering that for admission, that can be redacted out. It can just say quote and then blacked out quote. So it's clear that there was some quotation that was going to be included that got altered. And asked if there were any other portions that y'all would like similarly redacted, and that was the only one I heard. But
all right, thank you.
We'll, if you notice one when they're being tendered, just let me know that, and we can handle that as well.
Will do. Thank you.
All right.
Your Honor, as it relates to the correspondence to and from Mr. Wright and the state, I just want to make sure that there's not the state intends to, for the purposes of proving their existence, to tender them, and of course with the redactions that we told the defense and the court that we would make. But as I'm thinking over it as an evidentiary matter, the existence of the request itself is evidence that we think should be permitted at trial.
Okay, and so what is it that you're saying?
For instance, I would be tendering the November 30th email in response, requesting a conversation with Mr. Sledge. Given the cross-examination, did the state ever try to sit down and talk with you? Did they ever request to talk with you about Jeffrey Williams? All of those kind of questions prior to making the December 28, 2022 plea. So the existence of the request itself is evidence that we would be tendering, not just making the inquiry of Mr. Wright.
Okay.
Well, they'll have a witness on the stand.
Yes.
That they can ask whether or not that request was made, and that witness can testify yes or no. If, depending on what that witness's response is, there may or may not be a need to impeach that witness.
I'm not-
And so I can't think of any way that, any reason, any legal reason that the document itself would be necessary unless for some legal exception. For example, impeachment.
The existence of the request itself is not an attempt to impeach Mr. Wright. It's me tendering a request that was sent to Mr. Wright through
Well,
Mr. Wright.
Well, the document.
Don't interrupt, please.
Excuse me.
Remember, we had decided that we weren't going to be interrupting each other?
Understood. I thought she was done.
In terms of hearsay, if that's what the objection is, the hearsay, there's nothing hearsay about it. The document itself, it does not constitute hearsay. We're not offering it for the truth of the matter that it's actually just a request. And the document, the existence of the document is evidence in itself.
My,
Okay.
may I respond? My position is that it is a statement from the DA's office, from the author of that correspondence. It is not a court statement. It would be hearsay, but more importantly, it would not be necessary. The evidence that they're seeking to introduce is the fact that there was a request made or not for a meeting with the defendant. And if the witness can testify to that fact and it testifies affirmatively, then there is no need for the introduction of the actual document itself.
Okay, but there's no evidentiary rule that says that if you can get the information in through the witness, you can also offer a document that shows the same thing.
But then what would be the purpose of them offering the document if they have the testimony?
Further proof. All right, let's get the witness in.
Over here. Jasmine. Over here. JB. Okay, this looks good. Okay. This is perfect. Okay, so we'll call. What is it? Oh. Your Honor, Miss Lieutenant Wright, Lancico is showing me correspondence from Mr. Wright that was received today at 7:53 a.m. Good morning. Is he still a few blocks away? Good morning. Traffic has been terrible. I am a few blocks away from the courthouse, but depending on how long it takes to navigate these blocks, park, and get into the courthouse, I might be just a little late. I'll ask her to call him because we reached out at 7:53. So I'm going to ask her to call him.
Okay, so is he not outside right now?
I'll get her to call him
Okay.
right now.
Hope it doesn't take an hour to navigate a few blocks around the courthouse. All right, so we'll be in recess until we have the witness.
My apologies.
You're welcome. He's here. He's here, Mr. Weinstein.
Y'all make sure y'all hit that like button, hit that subscribe button. It's Ghetto DVD.
We're ready for the jury.
Good morning. Your Honor.
Morning.
I apologize for being a little late.
We just now got ready anyway. Thank you. Thank you. All right, everybody can be seated. And before we pick back up with Mr. Wright, let me just, while I'm thinking about it, I know there had been a couple of inquiries, I think maybe from the jury and from attorneys about what our plans were going to be for Election Day, November 5th. And my plan is to have court that day, and I'm going to have my assistant forward the list of early voting locations and times. It appears that Fulton County has early voting starting October 15th and running all the way through November 1st. And that includes Monday through Friday, Saturday and Sunday hours, and almost 45 different locations during early voting. You can vote at any of their early voting locations. It doesn't have to be your precinct. So anybody who wants to vote certainly is going to have plenty of opportunity to early vote. We will probably adjourn court a little bit early, maybe a few hours early on November 5th, but we're not going to take that entire day off. All right. Okay, Ms. Lev, go ahead and continue with your examination.
Thank you, Your Honor. And good morning again, Mr. Wright. How are you?
Good morning.
Judge, with the court's permission, I'm going to just use this microphone.
Yeah, that's fine.
Mr. Wright. Never mind. Mr. Wright, yesterday we were discussing representation of clients that you've had and your responsibilities as it relates to them. Would you tell the jury what it means to make an entry of appearance when you begin to represent a client in Fulton County Superior Court?
When we are hired to represent a client, and this is really civil, criminal, anything, you make an entry of appearance with the court so that you are officially letting the court know, I have been retained to represent this individual in whatever the matter is. That entry will generally, that's right. That, I'll just sit back. That entry of appearance will identify the court, identify yourself, identify the client, and basically shows your role that you are officially in that case.
Is it required that you make an entry of appearance anytime that you begin to represent a person in a criminal matter in Fulton County Superior Court?
Yes.
And once you make an entry of appearance, does that announce to the court, the state, and any other attorneys that are interested that you solely, along with whomever you designate, are the person that is representing that person?
Essentially, yes.
Right. And once you make an entry of appearance, are you bound to that person until you yourself just, better question.
Yeah.
Once you make an entry of appearance, can you unilaterally decide, I'm tired of you, I'm gone, and do nothing else?
Let me answer it in two ways. In terms of the court seeing you as the official representative or the authorized representative of that person, until you're released by the court, you remain that person's attorney as far as the court's concerned. Sometimes there may be a falling out or just a parting of ways between attorneys and clients prior to that. But until you get the court's approval on a motion to withdraw or substitution of counsel, but until you're released by the court, you remain that person's attorney.
Would you tell the jury the steps that a criminal case, for instance, when you send in an entry of appearance or file an entry of appearance, is it always at the same place in a criminal proceeding, at the very beginning, middle, end?
It really depends on when you're retained by the client or the client's family. Sometimes you can come in the very beginning before a case is indicted. That's when you hear words like prelim or first appearance or things of that nature. Or much later on at indictment, where you have arraignments and other initial proceedings for indicted cases. Or sometimes you're hired much later in the process. The case may be on the trial calendar already. So it really varies with each case. When do you actually come on board?
Do you recall the stage of trial or the stage of the criminal process for case 22 SC 183572, this particular case you're testifying in, or the predecessor indictment that this superseded? Do you recall the point at which you filed an entry of appearance for Antonio Sledge, the point in this case, not necessarily the date, just where the case had gotten to?
I don't remember the exact date that I filed an entry of appearance, but I was involved in the case before it was indicted, meaning he was affected by this case long before indictment. So we had some initial things, a preliminary hearing, and things of that nature that we had to deal with. So I can't give you a date, but very early on, even well before the case was indicted, I was involved in the case.
Okay. And when you say you were involved in the case, are you specifically referring to what ultimately turned out to be this indictment?
Yes.
All right. When you have filed an entry of appearance and you remain on the case, and the case is placed on a trial calendar here in Fulton County Superior Court, and it reaches, say, a final plea stage, would you explain to the jury generally, not fully in detail, but what final plea means as you understand it here in Fulton County?
Okay. To give you a quick primer on criminal cases, once the case is formally charged or indicted, you have an arraignment. That's where you formally plead guilty or not guilty. Then you have what we call sort of a discovery. That's where the state provides what their evidence is. The defense, we file motions to suppress, motions for more discovery, motions for experts. I mean, a variety of stuff, but we're sort of developing the case to make sure we're getting everything out and sort of on the table. Then after that process has sufficiently occurred where discovery is exchanged, certain motions may be filed, may be heard. Eventually, the court puts it on a final plea, which says, hey, all this stuff has been done. Have you come to a decision on what you're going to do? Do you want to proceed with trial or do you want to resolve the case? And a final plea date is significant because there's generally two kinds of pleas. There's non-negotiated and negotiated.
Before we get into that part, are you able to encapsulate without going further down the line into non-negotiated and negotiated and all of that? Are you able to just encapsulate what that date is?
In terms of what a final plea date?
Yes.
Well, final plea is your Fisher cut bait date.
All right. And
Okay.
on that Fisher cut bait date, are your only options to enter a play, go to trial, or do you also have the opportunity or ability to request something different than either going to trial or entering a plea?
I would add a third. Take a plea, go to trial, or beg for a continuance. So sometimes you can get it, kick the can down a little bit and say, hey, we need more time. So one of those three, and it still brings you back to final plea date is either
At a later time, though.
yeah, at possibly a later time. It's, are you going to take a plea or do you want to go to trial?
All right. And are there any particular reasons that might guarantee you a continuance? Any particular of any sort?
If there's a major issue with discovery, something that either hasn't been disclosed, sometimes a medical condition of the attorney, the client, something extraordinary generally. Some courts are a little stricter on holding that final plea date and holding our feet to the fire, and other courts are a little more flexible.
Were you to tell a court that you simply are not ready, you cannot be effective, are you generally given a continuance if you request one?
Generally, yes, and I would caveat depending on the judge, depending on the court. Some courts, again, are much more firm and strict because, again, they're trying to keep cases on track.
Right. Will you know what the court is going to do without asking?
Generally, if you've been around long enough, you've gotten to know the tendencies or the requirements of the different courts, yes.
Let me ask a better question. Can you state with certain whether you're going to get a continuance if you don't ask for a continuance?
Your Honor, I'm going to object for relevance.
Sustained.
All right. So, are you able to tell the jury if you were Mr. Sledge's attorney even before this case was indicted?
Mhm.
Did you appear with Mr. Sledge at a plea and arraignment? Was there a plea and arraignment for him that you were a part of or someone on your behalf?
I'm not sure. And to explain that, this case occurs. I have a heart attack in March of, 22. So from that March 22 and then heart surgery, I'm off the grid, out of practice essentially until December. So of 22. So
Okay.
I'm out of pocket for about 9 months. So there are things which may have occurred before that, like, and I just don't remember if the arraignment had already occurred or not. I'm not sure, but I may have missed some things in that 9-month period when I'm on leave of absence. When I came back, I think arraignment, everything had already occurred because I think we were already quickly moving towards trial count.
And were you already in conversation with the state during the time, even before you appeared back in court regarding this case and your client? Before December 28, 2022?
I believe the sequence was in November. The state sent sort of a inquiry email, and I then contacted my client to firm up, hey, am I still your guy? Am I still your attorney? And are we going to be moving forward? And I think they also had to know, are you ready to come back? Well, my client. And I also had to make sure that, hey, I've passed all the tests, I've done everything necessary to be able to resume my practice. Everything fell into place. I did come back, and by December, I think, was when I started to communicate that, yes, I'm still his attorney, and we started to move forward with different things.
I'm showing you what has been marked as State's Exhibit 450 Yankee. Would you take a look at that? And Your Honor, it's the 450 Yankee you've identified previously.
Thank you.
Without reading into it, without reading it out loud, rather, would you please look at it and tell me if you recognize the document that I have placed before you that is labeled 450 Yankee?
I do.
All right. How do you recognize it?
This was an email that was sent to me, like I said, in November. And it was, when we receive a letter of this nature, it's sort of an inquiry.
Without getting into all of the details, is that an email that I sent to you on November 30th?
Yes.
All right. Is there an attachment to the email that is also a part of State's Exhibit 450 Yankee?
Yes.
All right. And did that attachment also make its way to you in that email on November 30th?
Yes.
Is that a fair and accurate copy of both the email and the attachment that you received from the state on November 30th, 2022?
Yes.
Your Honor, the state tender states 450 Yankee as evidence.
It's admitted.
Mr. Wright, would you please read the body of the email itself? Just, and by the body, I'm talking about, yes.
Okay. Good afternoon, Attorney Wright. It's always good speaking with you. In the event that your client wishes to speak with the state in this case, I've attached a standard proffer letter for your consideration. Please let me know if you can provide any further assistance. Adrian.
Now, looking at the proffer letter that is attached. All right. With the court's permission, I'd like to publish the proffer letter. It's a blank proffer letter, but it's a,
You may.
thank you. And for the record, this will be pages 2 and 3, I believe, of State's Exhibit 450 Yankee. Are we signed into Zoom? Okay. Everybody has
You
it.
should be now.
Thank you. While we are pulling that up, with a simple yes or no, is a proffer letter the same thing as a plea agreement?
No.
All right. And is that distinction made within the proffer letter that you received?
The general language distinguishes between,
Scroll up to the first.
or at
paragraph.
least makes it clear that this is not in itself a plea agreement. This is really just an agreement to start having conversation between the state and the client.
All right. Mr. Wright, are you able to see the first paragraph of the proffer letter that is before you on the screen? Can you see that? I have some readers if you don't.
No, I'm just trying to clear this audio box.
May I approach and
You may.
Right. I don't want you to read the entire document that's in evidence, but would you please read into the record just that first paragraph, starting with Dear Mr. Sledge?
Okay. If I just read off the letter itself.
That is fine.
Okay. Dear Mr. Sledge, the Office of the Fulton County District Attorney, Atlanta Judicial Circuit has been informed that you may wish to make a proffer for the purpose of providing information that you may have regarding the individual or individuals involved in the enterprise Young Slime Life hereinafter YSL, or otherwise have information regarding your own involvement. This is not a cooperation agreement or a plea agreement. The following terms will govern any proffer session with you.
Okay. Now, without going into each of the terms, was a requirement of the proffer agreement, and starting with this particular one, that Mr. Sledge actually sit down and have a conversation with you present, along with an investigator with the district attorney's office and a prosecutor from the district attorney's office.
Yes.
And
Hit that like button, hit that subscribe button, if y'all in here.
2022 to you was Mr. Sledge's complete truthfulness and candor, material conditions required in this proffer.
Yes.
All right. Did the proffer letter inform Mr. Sledge that if he knowingly withheld material information or willfully made false or misleading statements during the proffer, any statement made or other information provided during the proffer could be used against him in a subsequent proceeding against him for perjury, obstruction of justice, or making false statements to law enforcement?
The letter does give that notice.
Okay. Does the letter also inform your client that if he or any person acting on his behalf subsequently takes a position in any legal proceeding that is inconsistent with what is contained in the proffer, whether in pleadings, oral argument, witness testimony, documentary evidence, questioning of witnesses, or any other manner, the district attorney may use the statements in this proffer and all evidence obtained directly or indirectly in any argument and for cross-examination, impeachment, or rebuttal evidence.
It does say that.
All right. Barring those circumstances, was it your understanding that the proffer would be used against your client?
Generally, when we do a proffer, it's sort of a, whatever you say, it's sort of a, what a queen for a day. You get to say it.
Explain
without-
queen for a day to the jury.
You get to basically say whatever you're going to say and it not come smack you in the face, meaning it's not going to be used against you and hit you over the head with whatever you tell them. It's a way that the state evaluates the information that you have without you being in a position where, well, now that we've had this conversation, you're using it against me. Well, I never should have said anything to you. So that is, the proffer is designed to sort of both sides be able to feel where the other side's coming from without anyone lessening their legal position.
And have you just described what your understanding of this proffer agreement or proffer request was?
Correct. Any proffer on state, federal, I sort of hold that general opinion.
Okay.
It's a case-by-case basis, whether it's good or bad.
So let's talk specifically about the language in this proffer. Does paragraph 2 of this proffer read, the Office of the Fulton County District Attorney herein after referred to the district attorney requires complete truthful statements from you, Any statements made by you at this proffer cannot and will not be used against you in any grand jury proceedings or at trial against you in the district attorney's case in chief. No statement made by you during this proffer will be used against you to increase any future recommendation by the district attorney as to an appropriate sentence for you should you be charged in this matter. However, this agreement does not apply to any previous statements you made to law enforcement officers.
Your Honor,
Yes, sir.
I'm going to object under relevance and also 403 waste of time.
Your Honor,
Yes,
as it relates to questions on cross-examination about whether or not a request was made to sit down and speak with Mr. Sledge and Mr. Sledge's answer, the contents of a request to sit down and speak with Mr. Sledge and the circumstances or the requirements are relevant for the jury to assess any information they hear from witnesses on the stand.
okay, well, they've heard that occurred, so move on.
Thank you.
Sustained.
Thank you. Did your client agree to sit down with the state before entering into plea agreements with the state?
You know, I don't have any memory of us actually doing the proffer. I was going to ask you if you have a signed proffer agreement. That might help refresh my recollection. I remember receiving the proffer, at least the proffer letter. And then later on, we ended up in a plea negotiation, but I don't recall us actually executing the proffer process
Do you
before that.
Do you recall any verbal communications with the state conveying that your client did not wish to give a proffer? Do you recall any?
Hang on.
Objection, Your Honor, leading and suggesting an answer.
I'm not suggesting an answer. It requires a yes or no answer, but it does not suggest one or the other.
Overruled.
Do you recall any verbal communications with the state?
Again, because I don't have any recollection of actually doing the proffer, I do not think that we were in a position that we accepted the invitation for a proffer. I also have a specific recollection that a few weeks later, I then, based on some things which were sort of happening with the case, reached out to you, knowing the proffer had been extended and knowing, okay, like to have some more discussion about maybe resolving this case.
Okay. Did any part of that involve your lying or your client agreeing to sit down with me to have a discussion before he entered into a plea agreement?
I just don't have a memory of having a conversation with you prior to the plea. So at this point, I would say I just don't recall that. If it did occur, if you can refresh my recollection, but I don't recall there being a meeting between y'all.
If your client wanted to meet with the state, would you have arranged it?
Well, yeah, we certainly, if my client had expressed an interest, then I would, of course, it'd be my duty to follow up on that.
And would you have, based on your practice, would you have sent that via email? How would you have conveyed?
It may have been a phone call, but more than likely I would have emailed, so I would have had something in writing to confirm it. And if there had been such a meeting, there'd be a signed proffer letter because I would have wanted the protections of the proffer letter in place before that meeting. I wouldn't have put them in a meeting without a proffer.
Have you had an opportunity at my request to go through all the correspondence between you and the state as it relates to your client and this case? And let's stop there. Have you had an opportunity to go through your correspondence?
I have.
Is there any email, note, letter, designation from you that you were able to find that gives you any belief that your client at any point wanted to sit down and talk with the state?
No.
All right. I'm going to show you what, in your honor, we will, pursuant to conversations outside the presence of the jury, modify 460 as necessary, but
Okay.
as I'm going to show defense counsel 460, I would like to approach the witness after they've had an opportunity to look at 460.
Okay. Is 460 wide?
460 Yankee, thank you, Judge. For the court's edification, we're reviewing the paper packet that I provided the court in the defense yesterday.
All right, thank you.
Your Honor, as they will come up there as well, I'm gonna go ahead and provide both to the defense and to the court, a document that I have labeled 461 Yankee and 462 Yankee. I'll provide 6 copies for the fifth, 6 copies for each, and then 1 copy for the court.
All right, thank you.
You're welcome. Later copies.
Thanks.
And I've labeled them 461 Yankee court copy. I'll give it to the court. Permission to approach the witness with 460 Yankee. Without reading out loud anything that's on 460 Yankee, do you recognize correspondence from you to the state contained in 460 Yankee?
I do.
And does that correspondence accurately reflect or contain the entirety of the correspondence that is listed within 460 Yankee that you sent to the state?
I believe so, yes.
As you reviewed the correspondence that you sent to the state at my request this weekend, did you find anything as it relates to this case in addition to what's contained in 460?
I did. Ultimately, what I was sending to you in that exhibit was some of the stuff I had found to make sure that I guess everyone was on the same page as to what our correspondence was.
And showing you 461 Yankee and 462 Yankee without talking about what they are those additional emails that you sent to the state in response to the state's request that you provide all the correspondence that you sent to the state regarding this case and your client?
Yes, this does look like an email that I sent, which was a compilation, same kind of thing, sending you old emails regarding this case.
Do you see anything between State's Exhibit 460 Yankee and 461 Yankee and 462 Yankee that is materially different from the correspondence you sent to the state regarding your client's case?
I do not.
Do you see any difference, any omissions between what you actually sent to the state and what is contained in 460 Yankee, 461 Yankee, and 462 Yankee?
I do not.
Your Honor, I'm placing witness Winfrey 450, which is I'm now going to ask you if you would take a look at 451 Yankee, Your Honor, and this has already been labeled and provided to the court and to counsel. Would you just take a look at 451 Yankee?
Okay.
Does 451 Yankee accurately reflect correspondence sent from the state to you on December 27, 2022 at 4:57 PM?
Yes.
I'll hold that right here, okay? Looking at 452 Yankee. And when you look at it, after you've read it to yourself, would you tell the jury whether 452 Yankee accurately reflects correspondence sent from the state to you on December 27, 2022 at 5:06 PM?
It does.
You see any material alterations?
I do not.
Looking at 453 Yankee. Does 453 Yankee accurately reflect correspondence sent from the state to you on December 28th? That's Wednesday, December 28th, 2022 at 1:45 PM, and that's 453 Yankee.
This appears to be an accurate copy.
Do you recognize or see any material alterations or deletions?
I do not.
Showing you 454 Yankee. Does 454 Yankee accurately reflect correspondence sent from the state to you on Wednesday, December 28, 2022 at 1:46 PM?
It does.
Showing you states 455 Yankee. Does 455 Yankee accurately reflect correspondence sent from the state to you Wednesday, December 28, 2022 at 1:54 PM?
It does.
And showing you State's Exhibit 456 Yankee. Does 456 Yankee accurately reflect correspondence sent from the state to you on Wednesday, December 28, 2022 at 2:34 PM?
It does.
And showing you what has been marked already as State's Exhibit 1AS. Do you recognize that as the agreement that was ultimately signed by you, your client, and a member of the state on December 28, 2022?
Yes.
And looking at State's Exhibit 444 Yankee, is that an identical version of 1AS? Just label it the difference. That's purposes.
It appears so.
Do you see any material alterations or deletions?
No.
Is the document that for the purposes of the hearing was labeled 1AS and for the purposes of this trial was labeled 444 Yankee? Was that document signed and agreed to before or after the documents that you just reviewed that have been labeled as states 450 Yankee and 451 through 460?
I'm sort of lost. Your question is, were the last two signed
No.
after receiving the other ones? That's why I'm not sure of your question.
Thank you for that. All right. Are you agreeing that the?
Yes.
Your Honor, I believe that.
Overruled.
Are we, your testimony is that 444 Yankee and 1AS are the exact same documents, so I can just use one?
Correct.
All right. So the document that is 1AS, was that signed after State's Exhibit 450 Yankee was transmitted to you?
Oh, let's not do them individually. Just ask the question again and maybe he'll understand it the next time. It's just a time
Let's try it.
sequence, right?
It was.
Okay.
So, my question to you is, the document that is labeled 1AS, was that signed and agreed to before or before any of these documents that you just reviewed were transmitted? That's my question.
Okay. Let me answer it this way, because I want to make sure I'm on the same page.
How about asking for the clarification you need?
The
How
la-
about let him answer and maybe he'll be able to
Yeah.
answer what it is that you're trying to get at anyway.
The documents you've been showing me were all drafts of the plea agreement that were works in progress as we were proceeding. The first couple were the day before the plea. That's why they're in the evening. Then when we showed up to court that next day, while I think the format was y'all were in a conference room, I was in the back and shuffling back and forth, but you would email me and that way I would go over the different versions with my client. But what you just showed me were different versions, which were evolving as we were getting closer to a plea agreement that we would execute and sign. The signed one, which is this 1AS, was the final version that ultimately got executed, that he signed, and you could see, I guess, with Judge Glanville, when we did the plea, that was the one executed. Ultimately, I have some concerns, but I'm acknowledging this is what we signed. This is what we ultimately did for the plea agreement, and the other renditions or iterations were showing the progress going from point A where we had no agreement to expressing what our concerns were to getting an agreement hammered out. Does that, so all those were before this one.
Thank you, that was the only thing. Thank you.
Okay.
Did the state ever request to talk to your client without you?
No,
Did you ever offer up your client to talk to the state without you?
no,
Was the only way that the state communicated with your client through you?
correct. Either through me or with me present, but not by himself.
point where December 28, 2022, where this case was soon to begin trial, were there options that you had in terms of going to trial, taking a plea, or asking for a continuance?
Again, let me answer it this way. I'm not trying to be difficult, but an explanation. Legally, yes, we had options. We could go to trial or we could take a plea. Those things all in the very mundane, simplistic way, yes. But then as a practical way, my client didn't have the resources where he could hire me to conduct a year-plus trial. So those resources weren't there. So he also expressed other concerns he had unrelated to the trial. So you'd have to ask him as to what was going through his mind. But there are a lot of different factors that go into that. It's just not a simple yes, no. But yes, did we have different legal options he could choose? Yes. But why he made the choices he made, that's something you'd have to ask Mr. Sledge.
All right. And is it safe to say in here during the time, the questions of those sorts put upon Mr. Sledge?
Yes.
All right. And when you spoke about your client not having the resources to conduct a year-plus trial, did you ask to withdraw from the case at that point?
I did not. Ultimately, whether or not I would ask to withdraw and remove myself so he could either try to get appointed counsel or get new counsel, that would come after he makes a decision of what choice does he make among his different choices. Because he chose to go forward with the plea, then we never reach the issue of that.
And did you ask for a continuance at that point?
We did not. Well, I don't believe we did. However, I think I had been fully cleared to conduct trials, but I just want to say it might have been, it was right around that time frame. In fact, I think I had just finished a jury trial. So I think I was already cleared. So no, let me go back. We did not ask for a continuance.
And did you convey to the state certain things that your client simply could not agree to as it relates to some versions of iterations of the plea agreement?
Yes,
Without talking about what they were?
Understood.
Okay.
What I'm saying is we definitely discussed different things that based on where my client's position was, where the state's position was, some things we were able to work out as demonstrated in the different iterations. And then there were some things we could not.
And Mr. Wright, my question is only, were there things that your client insisted, or that you insisted on behalf of your client, that the state changed in
Yes.
its final form? Were there things? I don't mind any explanation.
I'm going to say yes, and here's the explanation. Almost all the things we asked manifested itself in iteration number 3. That was the version before version 4, which is the one that ultimately got executed. So when we were looking at version 3, we saw everything and we're good to go. Version 4 introduced item number 8, which was not what he wanted.
And is version number 3 the one that is marked State's Exhibit 456 Yankee?
Could I?
One AS. One AS.
Yeah. No, this is not. When I'm referring to version number 3,
Do me a favor, I'm gonna give you all of the ones you just looked at,
okay,
and you identify by
exhibit number.
exhibit number, which one you're referring to as version number 3. I'm gonna remove 456.
Your Honor, excuse me. Before the witness answers that question, do you mind if Mr. Shaw and I step up and take a look at the exhibits? We're just not sure that we have.
Sure, that's fine.
Which one would the court like me to give to, give us to all? Your Honor, may I please remove them from Mr. Wright's possession? Let them confirm that these are the ones that they were given yesterday?
Yes, and then give them back, yes.
And if they have the ones.
I
they
think
can
it's
compare.
more which one is which.
Okay, I did name them on the.
I know, but.
Your Honor,
Yes.
excuse me, I appreciate that it's early in the day, but could we just have
Yes,
5 minutes?
Yes, let's take our morning recess while we do this.
Thank you.
Good idea.
I think it's 455. These are my.
Oh, those are yours.
Yeah.
Hey, Your Honor, just so that the records are clear, if anyone from counsel from the defense could just bring the ones that they had up from yesterday here, because I gave them numbers.
If they want to do that, sure, they can do that. I mean, I think these are the things that were originally sent over as electronic copies, and that maybe, and they were like a file within a file kind of thing. So that's probably what the complication is.
And
Yes, you may.
Your Honor?
Yeah, and we're going to take a, yes.
I was going to, because they're going through the documents, and I shared with counsel for the state when she came up, the document I believe I was looking for is 455 Yankee.
Okay.
But I'll confirm it when I get them back.
Okay.
But that's the one that I think is the one that I'm looking for.
Okay, well, you'll get them back and we'll do that in front of the jury.
Yes, Judge.
I mean, you can certainly look through them, not in front of the jury, but we'll confirm whichever one it is once we've got the jury back. Okay, so we'll take like 15 minutes so that y'all can take a look and everybody who needs to can use the restroom. Yes, sir.
May I ask if it pertains to these documents and this witness or something?
I think it, up at the bench, I think it was not these documents necessarily. Oh, yes, it was. Yeah. It should be somewhere within one of those documents. So are you going to tender those for admission, or are you just going to have the witness talk about them?
At this point, not before I do the necessary redactions. I'm not going to tender anything. I'm going to ask him about these things right now. And as I said, I will not tender anything until I redact.
Okay, but I think there's an issue with regard to what ought to be redacted.
So we could, I don't mind.
Why don't y'all just talk And then if y'all can come to agreement, great. If not, then we'll take it up. So, 10:30, I'll plan to come back. Okay. Okay.
So as it relates, Your Honor, to what we discussed at the bench regarding State's Exhibit 460. And State's 460 is the paper copy of Mr. Sledge's email, Mr. Rice emails.
Right.
On the next to the last, I'm sorry, the last page of State's
Yeah.
460. And Mr. Sharp is standing next to me, so if he has that, he could pull it up and confirm that I'm getting this part right. There was an issue at,
Well, look at yours.
you wanna look at mine?
Well, I don't, no. Continue, I was trying to interrupt. I don't have 460 printed out, so I'm just gonna watch on.
Okay, go ahead.
Okay, so at the bench, there was an issue, number 4, does the court have its copy?
I do.
All right, so there was no problem from counsel for the defense that actually voiced any concern about the first full sentence. The concern voiced by Mr. Adams, I think echoed by Mr. Sharp, was the second full sentence. And then they wanted to keep in the third and the fourth sentence. What I told them was that sentence, that number 4 was made in response to the email, and you can tell that from the time and date that it was sent. That was sent in response to the email that was sent to Mr. Wright, and that was dated December 27, 2022 at 5:06 p.m., which was State's 452 Yankee. The email that contains, and it may have been that we did include it twice. So Mr. Wright sent us an email on December 27, 2022 at 8:43 p.m. in response to the email that I sent to him that was subject Sledge Agreement Updated. And in that email, Mr. Wright enumerated 1 through 8 regarding factual acknowledgements. 452 is the email he was responding to that the state has sent. And number 4,
Yeah.
yes. And so to the extent that the counsel for the defendants have all indicated during the break that they would like redacted from any prior iteration, anything that was not included on the final States 1AS, the final plea agreement, to the extent that number 4 on States 452 Yankee gives context to that number 4 on States 460, it would be necessary to be included to show that that was something that the state put on there that it believed to be true, that Mr. Sledge said no, and this was his response through his attorney.
Okay, so I'm confused now on the different iterations that lead up to the final agreement. I understand that one of them is this number 4 that the state was proposing that he say
that he was saying
that he, Sledge, had personal knowledge that YSL Associates were planning to murder Donovan Thomas Jr. And that is not ultimately what number 4 said. But are you saying that
in response,
are you saying that the defense wants redacted the earlier version of number 4?
yes.
You're
Yes.
okay. I think we're going way down a rabbit hole here. The state seems to me, we don't need anything redacted if it's not being admitted into evidence.
Well, I think it is going to be admitted, or at least tendered for admission into evidence. And the reason that it is at issue is because Mr. Sledge said there were things that I absolutely wanted changed that didn't get changed. And this establishes that there were very material things that would have been beneficial to the state that got changed because Mr. Wright and Mr. Sledge requested that they be changed. So I understand why that is relevant. I mean, if these are going to come in, I would certainly think that we need an instruction that they're not to take any of this as factual, because it's not in fact what he ended up agreeing to.
I agree.
Yes,
Well, can I just?
yeah,
Some things.
okay.
First of all, I agree that Mr. Sledge said that. I also know that Mr. Wright and actually Mr. Sledge acknowledged that some things were changed, some things were not changed.
Mhm.
So no one is claiming that nothing was changed. Okay, that's first. But secondly, I want Your Honor to understand, and I sought clarity from the state because I don't work for the state. I was not communicating with Mr. Sledge back then. These initial factual acknowledgments were in no way based on anything Mr. Sledge ever said to the state. The state came up with these factual acknowledgments from a review of the discovery
Mm-hmm.
and proposed these. So
Right.
the genesis of these is purely divorced from anything Mr. Sledge stated. Okay? It's not, there's nothing that Mr. Sledge said, okay, this is my story, and then the state came up with these factual acknowledgments, and then Mr. Sledge was like, oh, well, you don't have that quite right. This is what the truth is. These were drafted by the state from looking at the discovery.
Okay.
So I would ask if we're gonna let in basically incorrect information that Mr. Sledge has never agreed to, and we're going to expose the jury to this, I think we need to be a little stronger with the instructions and say, these were drafted by the state and not based on anything Mr. Sledge said. Because I've been doing this for a while.
All right, I get your point. I get your point. And y'all, this is why I had us come a half an hour early, is because 8:30 to 9 was when we were supposed to be figuring out what was coming in, et cetera. But, so Ms. Love, are you not in agreement with redacting things that didn't ultimately come into the final agreement?
Correct, for the reasons that the court earlier alluded to, and also.
All right, and you do realize that some of what might come in like this, if the version of number 4 comes in that is a proposal that YSL Associates were planning to murder Donovan Thomas Jr., that there are concerns with putting that type thing before the jury.
Well, I do want to hear the court. I do want to understand fully the concerns that all of them that exist. And ordinarily, I would simply leave it at this. Yes, I know there are concerns, but in as much as Mr. Sharp has indicated that, well, his version of reality, mine differs slightly, and I would not go so far as to characterize.
I'm not going to give an instruction that says this is not based on anything. Okay.
Well, can I just respond to that though? But if you're not gonna give an instruction, Judge.
I am going to give an instruction
I understand, but
if this even comes in.
this is the problem. If this comes in, I think the jury would want to know, well, where did the starting point come from? And the only way we could bring it to the jury, because I didn't really know until this morning, to be honest, where the starting point was. It's always been a question of mine. How did these even get the first version? Where did it come from? The only way we could really bring that to the jury is to call the drafter of the acknowledgements to the stand, who I assume is Ms. Love, and ask, well, these acknowledgements that you drafted, When did you draft them? Was it based on anything Mr. Sledge said, or was it based on the discovery? Because, and I'm being 100% forthright here as an officer of the court, Your Honor. I've never been a prosecutor, but I was under the assumption that there was something that Mr. Sledge said that led to the first statements, and then it was like an editing process. But the first version was not based on anything Mr. Sledge said. And that's important, because the jury has to determine, okay, did the state just come up with these? Did Mr. Sledge say certain things and he's backing out of them now? And if we don't make it clear to them that Mr. Sledge was not the genesis of even the first version, I think that question becomes unanswered. And the only way, other than an instruction, would be to call Ms. Love to the stand.
All right, Ms. Love, what's your response to that?
Your Honor, one, again, the idea that
All
this,
right, I don't need like
I'm
a
not trying to go-
full-blown
my response,
rehash of everything. What is your, let me re-ask, what do you propose?
I propose that the court instruct the jury that it is to take as fact no information contained in any iteration of the plea agreement unless that assertion or that factual acknowledgement is in the final version to which Mr. Sledge.
Let me ask you this. Would you be able to get essentially the same information before the jury? And I believe the information you want before the jury is that very material things about the factual acknowledgements were changed at the request of Mr. Sledge and Mr. Wright. Is that essentially the point you want to make?
Blandly, yes. I think that I would rather ask Mr. Wright, did the state ask, because essentially that's what we're doing, because we couldn't sit down with him. Did the state ask your client if he had personal knowledge that the murder of Donovan Thomas was pre-planned by YSL members? Did we ask him that? And did, through you, your client, tell us no? Did he say no? He
So
doesn't
what
believe that the shooting was,
he says he did not know.
right.
He thinks it was not planned, but more impromptu, or at least very short or little planning.
Right. So we don't need all of that.
What's his basis for knowing that? I mean, that's part of their problem.
That it was impromptu with little planning?
Uh-huh.
Well, because he was at the house with, if we're talking state's theory, because Mr. Sledge still has not met with us, but if we're talking what we believe is that everybody was talking about it. They were at the house. We have more than one witness who says at Defendant Williams' condo, they met up. And
After
it was
the fact.
Yes, after the fact. And they talked about it. They talked about catching.
Okay, they could have talked about it and it never come out whether it was planned or not.
And based on the conversations, this is what I have gathered, based on the conversations that Mr. Sledge was privy to, his understanding was that it was not pre-planned. And that is the reason when he says what he does, that he says it. So we're not trying to get into what he thinks. We'd be sufficient with, did we ask him that? Did he tell us no? Did we at first have something
Okay,
to
so
that?
I think that's a
effect in
lot
it?
safer way to go about it is,
Yes.
did we ask him that and did he say no?
And did he?
And leave it at that and not follow up on, here's what he thought instead.
I
Okay,
completely agree. But
okay,
the
well,
part
that's
that
not
I
what you
think is
said a minute ago.
okay.
Okay, so
The part that
go ahead.
the part that I'm concerned about and would like to also put before the jury was, and did we include that question as part of the factual acknowledgments initially? Is that something that he absolutely said no
Okay.
and refused to acknowledge and had insisted that we change?
All right, so it seems like if y'all, the defense wants in portions of number 4, that maybe the sentence at issue could read, he thinks shooting Peanut was not planned, and then redact the remainder of it. Because that shows that he is saying, no, what the state is asserting is not true to my knowledge or belief.
And if the court lets me leave Mr. Wright, I can say, did he tell us? No. Did we
Okay.
ask him, did he have personal knowledge it was pre-planned? Did he tell us?
Okay,
No.
but if we're talking about how to redact 460Y if you
Okay, I see.
tender it,
Yeah.
then that would be, I think, a much safer redaction.
So taking out everything except he thinks the shooting was not planned?
No,
or
taking out, leaving in everything except, but more impromptu or at least very short or little planning. Mr. Sharp.
Well, I just have concerns with the state. Here's the state can have their theories. Mr. Sledge on the stand has said no one talked about the murder. Okay, I mean, they talked
Right.
about
At the
Mr.
coffee
Thomas.
shop.
Yeah, at the condo.
Oh.
They talked about Mr. Thomas had passed, but no one was saying this is what happened. There was no
Right.
discussion. So when you ask someone, if Mr. Steele asked me, hey, was that murder pre-planned? And I say no, then it insinuates, it gives the impression that I know about the murder. I have some information about the murder.
Yeah.
And that's my problem, is just saying that in a vacuum.
Okay. So how about, I mean, the beginning of what he says is really the answer. He said he did not know, and the rest of it is elaboration.
And Judge, the portion that was, let's see. Okay, so based on what Mr. Wright wrote back to me, we
Mhm.
included a line that was not initially included in the previous iteration that I think is 452Y.
Okay.
And I think that line is number 8. And we drew the same exact conclusion and I'm sorry, number 8 of 1AS, number 8 of the document that did get admitted, which is that defendant personally knows that one or more YSL associates committed the murder on behalf of YSL. So based on the response that we got from Mr. Wright, from Mr. Sledge, that was what we concluded too. And that is why we put in here number 8, which is different, and it may not be in the prior iterations, but as we went back and forth,
Okay. So, I mean,
Judge.
I think that it would be safer in terms of what gets put before the jury if you do this through question and answer with Mr. Wright. Would you be, I mean, you let me know whether you're going to insist on tendering, but.
I'm certainly not going to do anything the court says don't do.
Well, I'm
but-
not telling anybody how to
And I know.
try your case. That's not my job to do.
Understood. I'm not going to tender it before the lunchtime hour, at which point, if there is an issue that we need to hash out or I need to say,
Okay.
but at this point, I am very much intending to handle this verbally with
Okay.
Mr. Wright on the stand, because
right,
I
and
think
is
it's
that-
something that I can do clean.
All right. Is that going to be true with regard to also not tendering the different versions, just talking about them?
Right now, yes.
Okay. Yes,
Judge,
sir.
let me just point out that in regard, and just very briefly, because I don't want to, go back over everything we just discussed, but number 8, that's referenced by.
You're going to have to give me some
in the-
number 8 on which.
On 1AS, the final iteration.
All right.
of
I don't even have that in front of me, but I know it is. I just, there's a lot of evidence in this
It
case,
is-
and I only have 2 screens. So
Is the
give me a
one,
second. to
but I
get
can
it.
orient the court if it helps.
Just, if you'll just give me a second. Okay, that works too. All right. Go ahead.
So 1AS, section 8
Yes.
is the portion that Ms. Love just referred to, where she says that we made changes to the document based on what Mr. Wright said back to us. And so we came up with 8.
Right.
Defendant personally knows. Well, if the court recalls, that is what they asked Mr. Sledge about when he was on the stand, and he specifically disavowed it. He said, no, that's not accurate. That's not true. And so if we go back to what we talked about earlier this morning at the bench, my simple request was just that, and I think we may have reached there. I kind of got lost a second ago. Is that in regards to them sending this iteration and Mr. Wright sending back the response that shows up in number 4, all right, number 4, where he says, he said he did not know. That's the answer to the question. And I think that's where the court ended up, that's the only.
No, where the court ended up, and we talked about that yesterday, was he said he did not know was to the version that the state had proposed that said this was planned beforehand. And the answer was, he doesn't know that.
Right, but what we discussed at the bench earlier, and the reason we asked for this portion, for that sentence, the sentences reads, he thinks shooting Peanut was not planned, but more impromptu, or at least very short or little planning, is because that is speculation. That's his opinion. The fact, and you agreed earlier that.
Yes, with regard to whether it was planned or not, that's a separate issue from whether he knows personally that it was done by a member of YSL.
But maybe I'm just not understanding, because I took the court's previous ruling and I thought that they were going to redact. As a matter of fact, they agreed that they were going to redact that particular sentence. That's the only thing that we objected to, because that our position was simply opinion. It was speculation. The fact that it came from Mr. Wright doesn't make it any less speculation as to him trying to explain why his client thinks that. But we asked that be kept out. The court agreed, and we thought that that part was not going to be read to the jury or presented to the jury.
I don't think that part has.
It was the email, but that's what we discussed, because we were discussing whether or not these correspondences, including the emails, were going to be presented as evidence. The state said, well, we don't know, we might, we may, and our position was that, well, if this gets presented, we don't want that line should be redacted, just like the other line where they proposed the line about
What he had said.
Right.
Yeah, right. And that's what we're talking about right now. But that's an entirely separate thing from what number 8 ultimately ended up saying. So if Miss Love is going to somehow get from whatever it was he said, hang on.
Number 4, Ms. Rice email.
If she thinks she can get from, it was pre-planned, no, he didn't know that, he couldn't say that, to somehow that answer being the basis for putting in, he personally knew somebody did it. I mean, I don't know how she's going to get from one to the other, but obviously that is what they ultimately decided was okay to sign, and y'all can cross-examine Mr. Wright on that.
Your Honor, I'd also point out that how we got where with any of these assertions is not relevant or pertinent to whether or not the defendant, it does not make more or less likely whether the defendants did or did not do anything here. So how we got to any of these, in my opinion, is not relevant.
Well, Miss Love, you're the one that's putting them all into
I'm
issue
putting
right
them-
now.
I'm putting them into issue to impeach what Mr. Sledge said regarding his, regarding whether his.
Okay, so I think that you can ask a few more questions that establish that, yeah, there were very material alterations made from what it started to what it ended up with. And they were made at the request of Mr. Sledge. But frankly, you even have Mr. Wright on the stand saying, but there were other things that the state wouldn't change. So how you deal with that is up to you, but.
Since I want him to put in front of the jury everything that he recalls as being true, I don't care about the truth getting in front of the jury. I am talking about this idea that the state.
Well, the easiest way to do that is, so what was it that you wanted changed that didn't get changed?
Right.
And then why is it that well, that would be speculative, but I just said I wasn't going to tell y'all how to try your case, but okay. So we are not at this point going to be admitting any of these.
We're
We're
not
just going to be
tendering them to-
discussing them with him.
At this point,
All right,
correct?
yes, sir, Mr. Steele.
Your Honor, just to follow up on, I believe Mr. Shart said, would you also go through an analysis of confrontation clause? Because the statement now comes from a party opponent and it's used for litigation. It is a clear, to me, bullseye on confrontation clause. So it's really Ms. Love who should be testifying if the state wants to get that in, because that is a confrontation clause, because where it came from, all those questions cannot be cross-examined to Mr. Wright. Second-
Well,
okay.
okay, sorry, I thought you were
No,
finished.
second part, and I apologize, I'll be very brief. Second part is a 403 analysis. You know, it's like saying, Ms. Love saying to Mr. Adams, who represents me, did Brian Steele destroy the murder weapon in your presence or in the presence of Mr. Harvey? And then Mr. Adams responds, no. You know, that's really bad for a jury. That is really bad. And that's really what's going on here. So I would ask you to just limit it. The point is what you said. Did the state give ample opportunity to Mr. Sledge through his counsel to make amendments? Answer, yes or no.
Mhm.
Did the state make those changes? Yes or no? And he might say some not. And we may have to go into a portion by portion, but otherwise, I think that it's a wrong witness.